Rule 129, what need not be proved. Under Section 1, a court shall take judicial notice without the introduction of evidence of number 1, the existence and territorial extent of states, their political history, the forms of government and symbols of nationality, the law of nations, the admiralty and maritime courts of the world under seals, the political constitution and history of the Philippines, the official acts of legislative, executive, and judicial departments of the national government of the Philippines, the laws of nature, the measure of time, and the geographical divisions. The essence of judicial notice is that you no longer have to present evidence on these matters. So pag ang pinag-uusapan itong mga bagay na to, yung in-enumerate natin, accordingly, under Section 1, mandatory yung judicial notice. So with or without calling the attention of the court, judicial notice must be taken off by it on these matters. Okay, so judicial notice is the cognizance of certain facts which judges may properly take act on without proof because they already know them. Okay, so when is judicial notice discretionary? It is discretionary on the following matters. Number 1, matters which are of public knowledge. Number 2, matters which are capable of unquestionable demonstration. And number 3, matters which are ought to be known to judges because of their judicial functions. Example of number 1, public knowledge, is the location of a certain hospital, for example, in a certain locality. So example of number 2 is the fact that a poison kills. Then example of number 3 is the procedure that has to be followed in posting a bond or bail bond. So another thing that does not need the introduction of evidence to be proven is judicial admission. Accordingly, an admission, verbal or written, made by the party in the course of the proceedings in the same case does not require proof. This admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not in fact made. Example, a case of rape filed by G against H. During the cross-examination, if G admits na walang rape na nangyari, but instead there was a consent on her part, may nangyari sa kanila but walang rape, yung sasabihin niya na yon will be considered a judicial admission which does not require proof as to its truth or falsity. Such admission of G may only be contradicted if she is able to show that the same admission was made through palpable mistake or that the imputed admission was not in fact made by her. Rule 130, Rules of Admissibility. Okay, so objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. The only thing that we have to remember when we talk of object evidence is that it is an evidence addressed to the senses of the court. Ibig sabihin po niyan, when you present this kind of evidence, you are requiring the court for it to activate its senses, such as sense of sight. In the previously given example, the murder case between A and B, when the prosecution presents the knife that is alleged to have been used by A in killing B, the prosecution is in effect requiring the court to use its sense of sight and examine the object. So meron tayong tinatawag na chain of custody rule. Under this doctrine, the presenter of an object evidence may be required to prove its chain of custody. So this is very common. So the application of this rule is very common in drugs cases. For example, in the prosecution for illegal use of dangerous drugs, the police officers who conducted the buy-bust operation, specifically the police officer who seized the evidence from the accused, must show to the court how the pieces of evidence that have been recovered from him are taken care of. So from the moment that the piece of evidence was recovered from the accused, the seizing officer must show that such evidence was properly taken care of. Kaya meron tayong requirements such as the marking, the conduct of inventory, and the taking of photographs to prove essentially that that piece of evidence, when presented to the court, was the same evidence that has been recovered from the accused. Documentary evidence. Documents as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. When talking about documentary evidence, the only thing that we have to remember is that a document is a documentary evidence only if it is offered to prove its contents. So for example, yung contract between X and Y, the evidence of Y's indebtedness to X may be considered as a documentary evidence only if it is proved so the contract between X and Y, which proves the fact of Y's indebtedness to X, may be considered a documentary evidence only if it is offered to prove such fact, yung pagkakautang. Kung yung pagkakautang na yun is not the one in issue, or if it is not the one in question, or if it is not the one where the conflict arises between X and Y, but it is offered only to prove that there exists such contract, then it may not be considered a documentary evidence. In that case, it may only be considered as object evidence. Original document rule. The essence of this rule is that no evidence is admissible other than the original document itself. Sa binigay natin na example kanina, yung original na contract between X and Y is the only document that is admissible to prove that Y is indebted to X. So X cannot present in evidence a mere photocopy of that contract unless, of course, his case falls under any of the exceptions. Number one, a photocopy, for example, may be introduced in evidence if the original has been lost or destroyed, or cannot be produced in court without bad faith on the part of the offeror. Number two, when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. Number three, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. So letter C refers to a case when the contract, for example, involves a lot of pages and the court does not have a luxury of time to examine the document. In that case, the court may allow the presentation of evidence other than that contract. Then letter D, in the original is a public record in the custody of a public officer or is recorded in a public office. So for example, in land disputes, if you present a mere photocopy of the land title, that photocopy may be allowed by the court since the original thereof is a public record in the custody of the registrar of deeds. Lastly, when the original is not closely related to a controlling issue. So when the original daw is not closely related to a controlling issue, then presentation of that document may be dispensed with. So ito yung sinabi natin kanina, best evidence rule or primary evidence rule, original document rule, contents of original writing rule, refers to the rule which states that with the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself. So take note of this, subject of inquiry is the contents of documents. If the subject of inquiry is not the contents of a document, then a document that is so introduced may only be considered as object evidence. Accordingly, the original document affords the greatest certainty of a fact. Its opposite is the secondary evidence. We have already mentioned that when we classified uh, evidence. The purpose of the rule requiring the production of the best evidence is to prevent fraud. Kasi nga, madali lang mag-photocopy eh. Carbon paper copies are considered duplicate originals. So, yon. Xerox or photocopies are not admissible under the best evidence rule. Exceptions to the best evidence rule, so we have already discussed them. So what do you consider an original of a document? Accordingly, it is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. So yung negative daw ng isang picture or photograph is also an original. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shows to reflect the data accurately is an original. Okay, so meron tayong tinatawag na duplicate. Accordingly, it is admissible to the same extent as an original unless, number one, a genuine question is raised as to the authenticity of the original, and number two, in the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. So an example of a duplicate is a captured photograph of the contract, for example. Accordingly, it is admissible to the same extent as an original unless may mag-question ng authenticity of the original, yung contract mismo na pinicturan mo. Unless that is questioned, then the photograph version of that contract is admissible. Number two, it is not admissible if it is unjust or inequitable to admit the duplicate in the original. So a document in the context of evidence is a deed, instrument, or other duly authorized paper by which something is proved, evidenced, or set forth. Earlier, we have discussed secondary evidence or inferior evidence when we classified the classes of evidence. Okay, so what happens when an original document is unavailable? Accordingly, when original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence, and the cause of its unavailability without bad faith on his part, may prove its contents by a copy or by a recital of its contents in some authentic document or by the testimony of witnesses in the order stated. So ayun, pag nawala daw yung document or pag na-destroy siya or if it cannot be produced in court, pwedeng ma-prove yung contents or kung ano yung mga nakalagay sa document na yon by a copy, by a recital of its contents in some authentic document. For example, contract A nawala, and then meron palang contract B which mentions yung mga nakalagay sa contract A. Contract B may be introduced in evidence to prove the contents of contract A. And then by the testimony of witnesses, by the testimony of the witnesses. So, for example, kung sino yung mga witnesses who were signatories to contract A, pwede silang mag-testify as to its contents. Okay, so when may secondary evidence be admissible in evidence? Of course, you have to prove that there is due execution of the original, meaning when the contract was entered into by the parties, there was no fraud, there was no exertion of violence, there was no intimidation. So it is that the parties have really voluntarily entered into the contract. And the number two, you also have to prove that the document is lost, the contract is lost, it is destroyed, or it is unavailable. And then you also have to show reasonable diligence and good faith in your part in searching for or attempting to produce the original. So, hindi pwedeng dahil hindi available yung document or hindi mo mahanap dahil nawala siya, eh agad-agad na magsasubmit ka na ng document of course ng photocopy. Of course, you have to prove that you have exerted an effort and that you are in good faith na hanapin yung original na yon. Okay, so when the original document is in adverse parties custody or control, what do you have to prove for you to be able to present a photocopy of such document? You have to prove that the adverse party has been given reasonable notice to produce it. So kung hindi mo siya in-inform na ipipresent mo yung contract, for example, na nasa kanya, yung original, you may not be able to produce a photocopy thereof in case he refuses to produce it on a later date that you requested it. O summary, so ito yung sinasabi natin kanina. yung documents consisting numerous pages, for example, or numerous photographs or accounts, and the court does not have luxury of time to examine them. So, ito yung public record when the document is public record. Accordingly, a party who calls for the production of a document and inspects the same is not obliged to offer it as evidence. That is so that is understandable. Kung ikaw na party, you require the adverse party to produce the contract, for example, and you wish to examine it or inspect it, even if you did so, you are not obliged to offer it as evidence. Medyo napahaba yung discussion natin na. Siguro mag-break muna tayo. Okay? Thank you.